Good morning to you all. First of all, I'd like to express my happiness in being in the city. I come here often. Long back, my wife did her PhD just a few miles from here at the Indian Institute of Science. So back in 1992, I had come for about 6 months from US to stay with her as she was completing her PhD and be a full-time husband. So I had a lot of time with me, so I walked around all these places as many times as possible. So it brings me fond memories. To me, coming to India is always, coming home. So I always look forward to it. But I'd like to thank my colleagues, Mr. Peter McKenna and Susan Pan, who have traveled all the way from US. This is their first visit. And to be part of this program to the extent that we would like to take part in promoting IP culture and IP education. I'd like to thank them as well as my firm, Shugru Mine. I miss Mr. Miku Mehta, but Miku is he's a world traveler. He goes all over the place. He goes to places which I haven't even heard of. So for him, it's just a short hop. But I express my thanks to my partners. Now, I'd like to say a few words about my firm. We've been around since in the 50s as a patent law firm. In the early days, Shugru used to do a lot of the patent searches and patent application drafting, and then later on litigation became a very important focus. And we are now located in downtown Washington, D.C. We have about 100 attorneys in various areas of expertise, covering almost all areas of technology, and with sufficient support staff associated with that. We are an IP boutique. In that sense, we are different from a general practice law firm which does everything like contracts and all that. But we only do patents and trademarks. So that gives us a specialized knowledge in IP. And I believe it's a significant advantage because that's all we do, patents. And we are located in Washington, D.C. That has an importance in itself, and it's become even more important after Mr. Kapos took office as the Patent Office Commissioner. He's encouraging practitioners to do interviews with the examiner and try to arrive at allowable subject matter as early as possible. So being in Washington, we just can call up patent office examiners and talk to them over the phone, and in a half an hour's drive, go and talk to them and discuss the invention. It's quite important to have a face-to-face meeting, if at all possible. And we're also quite close to the Federal Circuit, which is the appellate board equivalent to the board that Mr. Chandrasekharan sits in Chennai. As I said, we cover a wide area of technology, wide variety of technical arts, and there's pretty much no area that we are not involved in. And our client base, we represent large corporations all over the world, Japan, Korea, EP. And of late, we have been representing a lot of the pharmaceutical companies in India. So we do a significant amount of litigation for pharmaceutical companies. In addition, we also have a sizable number of small business clients and individual inventors. So having said that, I'll now move on to the topic. Now let's look at the electronics and software industry. What I say is more relevant to software, but it's also relevant to electronics. The nature of both electronics and software industries is such that the R&D costs, the research and development costs, form a significant part of the overall cost. It's pretty easy to see in software. Like once, most of the effort is in actually developing the software. Once the software is made, it's either in a floppy or in a flash drive or over the internet, making as many copies as you want and sell it, manufacturing cost is almost zero. So bulk of the effort is geared towards the research and development. This is true of the pharmaceutical industries also. Now, most of the effort is in finding out what medicine works for what disease, and are there side effects and things like that. But once the composition, somebody has figured out the composition, making and selling it is significantly less expensive than the research and development cost. This is not true of the other manufacturing sectors, the mechanical, the automobiles. Their manufacturing costs and distribution costs are also as high. So this being the nature of electronics and software industry, intellectual property protection becomes even more important. Okay. Now another feature of this type of industry is that the research and development can occur anywhere in the world. Now you can sit in Bangalore and design a component which gets into the space shuttle that is launched from Florida. Or it's happening. Right now, people in Bangalore are developing software for all kinds of applications all over the world. And once it's done, putting all this together, it can be done anywhere. So essentially, the components are highly decentralized, and then putting it together, it can be done anywhere. And like I said, it's relatively easy to manufacture compared to the R&D efforts. And that also makes it easy to copy the research and development. So once the idea is out, many times, you have lost it. I mean, you have to protect the basic idea. I mean, let's look at a very successful effort, Hotmail. Okay. When Mr. Sabir Bhatia started Hotmail, before it was acquired by Microsoft, if anyone who can remember, originally, you could sign up with Hotmail for free. That was a very fundamental idea from a business standpoint. Because when you give this Hotmail addresses free, when something comes, there is no contractual obligation. Okay? So if the thing doesn't work or it's clogged, you can't complain because it's free. So his effort was to sign up as many people as possible and create a customer base. That was the first thing. The second thing was even more important. If you go prior to that, email meant you had to be at your computer. So when I send an email to someone else, I send the letter or the content, and it goes to the other person's computer. So I'm not saying this idea was, was originated with Hotmail, but he was the first success in that, where, he said, why should it be from me to him? We can both write in a blackboard and then give a password protection to a small area of the blackboard, which is which is a very fundamental concept that evolved, transmission of emails. What that did was to make emails, make geographical location independent of the email. You could be anywhere and log on to the particular site and see your email. And that feature we are using even today in all email, except the PDAs where the emails are pushed for different reasons. Every other email system, Yahoo, uses this fundamental concept. So as you see, a small concept can create a whole new way of doing things. Now let's assume that somebody's entire R&D effort was centered around this kind of a concept. Once the idea is out, everyone implements it. So IP protection becomes quite important, significantly more important in this kind of field than many other fields. Now, I don't want to use the term outsource. I've used it just to convey an idea. It has become a little bit of a pejorative. But the bottom line is a lot of work that is done in this location in Bangalore and other places is significantly involved R&D, but it's done for companies all around the world. And the same way, labor is also outsourced. And so a lot of software is written, which is now, one of the reasons that people cite for the success of what that we have experienced in the last 10 plus years is cost, low cost. Why is technology being outsourced to some location like this? Low labor costs, but that's not sustainable. First thing, the labor costs are going to keep going up, and then I've heard that yeah, we talk about outsourcing from United States to Bangalore, but there can be outsourcing from Bangalore to Coimbatore, and outsourcing from Coimbatore to even a small village. So wherever work can be done at a lower cost, it can keep moving. So it's not a sustainable model in the long run. But however, that may not be all the story. Maybe work is coming here because there's innovation. You're doing something at a less cost, not because the labor costs are low, but you're doing it in a more innovative fashion. Maybe there may be innovation in the design, there may be innovation in the way the business is conducted. So such an innovation model is what we need to strive for. And that's a sustainable model. If the reason why work is outsourced to such a place is because of innovation, that's a model that will sustain. So in the electronics and software industry, each one of us who's involved in that has to look at our product, look at our manufacturing, look at what we do, and see if there is innovation involved. And if there is innovation involved, then we need to seek protection for that. Now let's look at the innovation model. Okay. I'm looking at it from another angle. The researchers and innovators are fairly good at what they're doing. They are focused, they spend their education and efforts in a very small area, and they become good at it. They may be good at churning out the proof of concept model. But what about the rest of the product cycle? So just because I'm an innovator doesn't mean that I should be good at productization, fabrication, manufacturing, marketing, etc. That's where the big companies come into the play. They are good at those kind of things. So if I'm an innovator, now it's a common thing in places like Silicon Valley, like 3 people would get together and form a company based on some innovative idea. And once the company takes footing, they go for financing. So they go to the venture capitalists who are looking for places to invest. The venture capitalists, they invest money in this company. The first thing that the venture capital person, what he does once he comes into the company is to fire the founders of the company. And because the founders of the company are the technical people. They are the researchers. Their focus is that. They're not good at the rest of the product cycle. My question is, why should they be good? They can simply move on to the next innovation. Patents make it possible. Okay. So you do your innovation. After that, you get your patent, and the patent is a product that you're selling. For the innovator, patent is a product. Okay. So what this has done is it has taken a very abstract thing like technology or design and made it into a fungible product. So patents have made technology really fungible. So the innovators can do their innovation, get the patent, find a source of income for the patent, and move on to do the next innovation. Now, of late, this term patent troll has taken a negative connotation. But I'm a big fan of patent trolls because they make this possible. They make such a fungibility of technology possible. They are very essential cog in that whole machinery of getting the innovation to the product cycle. The term patent troll was actually coined by Intel to kind of vilify people who do this business. In fact, I've heard the senior leadership in Intel in conferences in the mid-90s, they wanted to find a term that will stick and give a negative connotation. But it's an essential part of the overall business cycle. So what patents have done in this is basically make technology very fungible. So that's a different reason, different approach to the same thing, why patents become quite important in the electronics and software industry. They are essential for protecting the innovation. It converts technology into something tangible. Rather than just this nebulous area of know-how, it is now converted into something that you can market. And once you get the patent, you get a revenue stream from the patent and then move on. So in that sense, patent is a product that is marketed. Okay, and it's particularly important for the type of activity that Indian researchers are primarily involved in. There are not that many big brand name products that come from here. Okay, we don't sell internationally televisions or even significant software products. So most of the work is going into some component of these products. So it's basically adding to the overall product cycle. So in that sense, patents become even more important than in places where companies that actually sell and make and sell products. Okay. A patent is basically a contract between an inventor and a country. Now, if you go back to the history of patents, essentially, it was the primary aim was to get the researchers to reveal their ideas. Now, the award of the patent was more like an incentive to reveal the technology, so that the next person, next innovator can start from that point. So I may invent a bucket. Someone else may come and take that bucket and invent a handle for the bucket. Now, if I keep the bucket as a trade secret, the person who came up with the handle would have had to first invent the bucket and then the handle for it. So with this kind of a concept, technology development would have been slowed down. So the founders, during late 17th century, early 18th century, all through the 19th century, the promoters of this idea, their whole aim was to get people to reveal their knowledge to the world. And the patent was kind of an incentive or a bribe to do that. So if you look at a patent, there's an exchange of value. There's a quid pro quo involved. The inventor reveals his knowledge to the world, and the government grants a limited exclusive right. Okay? The specification, the technical description part of it is the quid part of the quid pro quo. And claims, that's the property right that we were discussing in the morning. The property right is the pro quo part of it. So it's an exchange. And the patentee gets an exclusive right for that, for marketing whatever, And through this process, a significant amount of technology can be converted into a patent and then a revenue stream arising from that. The methods, designs, processes, database, etc. And basically mental steps that can be productized. I mean, like Mr. Chandrasekharan said in the morning, we cannot patent concepts themselves, but implementation of concepts can be patented. And again, this in the innovation cycle, something like a brain wave has to take place that will take us out of a traditional way of doing things. Now, oftentimes in development of technology, we get bogged down by what happened before. Okay. I've heard this story about how the horses in Roman Empire contributed to the crash of the space shuttle. Okay. Essentially, the chain is something like this. The space shuttle, the designers apparently wanted a tank that was a little bit bigger than what was used. But the people who were involved in transportation said that, no, we cannot transfer that sized tank because it has to go through a tunnel. The tanks were made in Colorado, and then it has to be shipped to the space launching pad. So the railway tunnels were limited in size, so you had to limit that. So why is the railway tunnel limited in size? It's because the design concept was a broad gauge line. You leave 2 feet on either side. That's the size of the railway tunnel. But why is the broad gauge line 4 point some feet? It has nothing to do with metric system, but why is it 4 point something? It's because the line was built by Britishers who used that system. So when they built the railway station, they had to limit it to that. But why did the Britishers build it 4 point something? Because when they first started the railway carriages, they had to use horse carts. Okay, but why is the horse cart that size? Because it had to fit the roads in all over Europe at that time. But who built the roads? Julius Caesar. The first roads were built by Julius Caesar. How did he do it? He asked his people to bring 2 of the fattest horses and measured their behind and build the road to that size. So something that started off there's a correlation which probably led to the bad design of the space shuttle engine. Now the point I'm trying to make is that innovation at any point, people who think out of the box and don't follow the existing way of doing things often lead to, and this is particularly true in the electronics and software industry. Once you have a patent as an issued patent, it can be used as a tool in generating revenue. It can be a source of income and basic part of the strategy of marketing your product or your technology. And often in some cases, especially at the early stages of development of patent laws, often money damages may not be that common, and you may have to go for injunctive relief in the sense that you're preventing somebody from making that product and selling it. So having said that about patents, let me look at how one can develop a strategy. Okay. First, you have to realize that IP is a limited asset. So in the sense that intellectual property protection has geographical barriers. So an Indian patent is valid within the borders of India. It has no value. So you have to find out which countries or which jurisdiction your product is going to sell and protect in all those places. So you may have to prioritize, getting patent protection in multiple jurisdictions can become quite expensive. This is particularly so in China, Japan. In Europe, also the same thing, because not only are there costs involved in getting the patents, translation costs are significantly high. So you have to focus on what is the product that you're going to sell and where you're going to sell it, and prioritize based on that. How important is the sales in multiple countries? Are you going to be purely a R&D resource, or are you going to be supplying parts and products, and who is the customer? And what's your overall strategy for all these countries? And again, at this point, one has to look at what's your competitor strategy. Oftentimes there's a domino effect. I mean, in some very narrow field of technology, because somebody started patenting, there are a lot of other players who also start patenting. Very important, golf. There are more litigations involving golf-related patents than in many others, complex area of technology. It's difficult to figure out why. It's just that some company with, making golfing products, golf balls, golf handles, all kinds of equipments that are used for golf, started patenting in a big way. And then the competitors had no choice. They had to. So the same, one has to look at what area of technology and what the other competitors are doing in evolving a strategy. And again, you got to look at what's going to happen 10 years from now. Because right now, people say that enforcement in China is not that strong. You may get a patent in China, but the enforcement there is not strong because the court systems are not as developed. But that is now. What about 10 years from now? It may change. It's likely to become stronger by the day. So companies that are having a sufficient foresight are investing in getting patents in China because the enforcement may not be there now. Same thing in India. India, there's a lot of backlog of cases in the Indian courts. I mean, even criminal cases are taking several years in some cases to come to the actual trial. So what about civil cases? What about property cases? So the patent cases to actually bubble up to that level may take a long time. So which means money damages awards may not be as forthcoming here. But you still can get injunctive relief. The judges often give injunctive relief in an ex parte fashion with a small hearing. They can. So sometimes that is most of the battle won. So if you get an injunction against a competitor, once the injunction is issued, then it becomes a criminal issue. If somebody violates that injunction, it's a criminal issue. So people are afraid of violating injunctions. So even though the court system may not be developed, but there may be aspects of it that's enough to provide protection. Okay. Based on all this, if you look at who owns IP today and who owned 25 years back, if you look at the list of companies, 25 years back, the leaders were a mix of technologies. That is, you had pharmaceutical companies, major manufacturing companies like, GM and GE. And of course, IBM was still the leader, even 25. But if you look at the list now, I can't read some of the here, but all the 10 are electronics and software related companies. You have IBM, you have Samsung, you have Canon, Microsoft, Intel, Toshiba, Fujitsu, etc., etc. All the 10 are from that sphere. So it highlights, based on whatever I said earlier, it highlights the importance of protection in this particular area of technology. One has to determine what's the potential value of IP to the products. And what is the market share and how you're going to protect it. Okay. Establishing barriers to competition abroad and preventing copying and preventing intrusion into your own markets outside. And licensing can provide a basis for generating revenue in that. So keep a focus on the future perspective. Patents have a 20-year life, and some of the core technologies may last longer. One example, I can think of is TiVo. If you have used TiVo's products, basically, what they actually came up with was this concept of circular buffer. That is, your memory is organized in a circle, and you can keep writing across, and the reading can be done in any part. So depending on how big the buffer is, that much of programming can be, saved in that. So they invented this concept and patented the whole, multiple aspects of that. They tried to sell their own products. But they're a technology company. They could not. They're Hitachis and the pioneers who were very good at making boxes, set-top boxes and selling, TiVo could not compete with all. So they stopped selling anything. It just came down back to just licensing their core technology. And circular buffer is so fundamental that that functionality that they intend to provide cannot be done without the circular buffer memory. So the core concept, even though once that is revealed, it's easier to go back and make products based on that. That core technology is so fundamental. So patenting aspects of that, implementation aspects of that, basically, because of that, TiVo is still surviving as a major company. Same thing with Affymetrix. It's another company. They make what's called DNA protein chips. So they figured out that the semiconductor chip manufacturing process can still be used for making DNA and protein chips and stuff like that, except that the last steps of the process, of a multiple step process or thousands of steps involved, last steps are instead of building silicon based transistors as the last step, you are making protein chips, adding on building protein molecules. So 99% of the steps are common and 1% of the step is different. Again, when they tried to manufacture these chips and sell, they again lost out to competitors who are much bigger in that. So they protected, and they are still surviving as a fairly strong company based on that. So one has to look at what your product is and develop your portfolio based on that. And once you have protection, then you can rely on that to get a significant enforcement advantage. I mean, if you can prove literal infringement of your patents by, or even doctrine of equivalence, where basically equivalent elements cannot be, used. So if we can use these two concepts to enforce your rights. And once you do that, a variety of relief can be obtained. You can get reasonable royalty for your products. Or in some cases, if you can prove lost profits, you can go for lost profits, which can be significantly higher than reasonable royalty. But the problem often is, proving lost profits is difficult, especially if there are multiple alternatives. But if that's the only alternative you have, you can prove lost profit. You can get preliminary injunction and permanent injunction. That is, you can prevent your competitor from manufacturing the product. One can go for costs, interest, and attorney's fees, etc. So some of the basic offensive strategies is, obtain U.S. and non-U.S. patents with broad claims. Have multiple types of claims within the patent. And effectively manage the portfolio. You get the patents that are most valuable for protecting your concept. And since patenting itself is quite expensive, if you realize that some type of patents are not going to be effective, just drop it, and that will help you in managing your budget effectively. And enforce the patents. It can be through litigation or licensing. Licensing is the best option. If you cannot, litigation you are using as a threat to enforce the licensing. And importantly, you have to have a defensive strategy too. You have to keep monitoring what other patents that your own product may be, or your own technology may be violating or infringing on. And you got to early stage, if you can identify the type of patents that you may be infringing, you can change your own design. So, for example, when you are at the design stage, if you realize that there are so many patents out there that you may be infringing, that's the stage when easily you can design around those patents. Now, if you cannot design around, then at least you can have a strategy of maybe trying to approach the patentee for a license and paying reasonable royalty. Now, doing that at the early stage will mean that you can do your costing on that basis. You can incorporate the cost of the royalty in your costing. But if it's done at a much later stage, it may be difficult. Once your product is already in the market, it may be difficult to do all this. And doing patent searches at this stage will be quite useful and effective in that. You can identify what the multiple patents are out there that you may be infringing. There could be direct infringement for importing into the U.S., direct infringement of patents that are in the U.S. that you need to worry about. Or you could be indirectly infringing the products. And then indemnification becomes a big issue at this point. So how do you resolve this? Basically you have to do an effective search and identify and see if you can design around. And negotiate indemnification clauses. Now, especially if you are selling a product yeah. All right. I get a cue. I'll try and wrap up the strategy part of it, and the last several of the slides I have put in for basically some issues that you need to be aware of in drafting good patent applications. So I'll just skip that section because it's already there in my presentation. So these are the ways you can resolve such issues when you're importing a product into the United States or a service. Now, on the other hand, Indian company licenses or purchases U.S. technology. Okay, in such a case, there are many different ways it can happen. It may be sale of companies, divisions, to sale of product line, Indian manufacturing research facilities in the U.S., or it could be universities or trade group. So you can have several types of technology licensing agreements in these scenarios. There are different exclusive, sole, non-exclusive licenses. There can be royalties. There are a wide variety of royalty schemes, lump sum, scheduled amount, etc., etc. So the issues that I discussed, can be overcome by adapting strategies that revolve around these. Okay. Now, these are some of the issues. Is the best mode of technology being transferred? I mean, are you getting the whole compendium of rights? Whether it's patent, trademark, copyright, the entire rights need to be. What about improvements that can take place in kind of a joint venture? So all these need to be kept in mind. So you can obtain adequate warranties and indemnification clauses and guarantees, and you may need to get invalidity or non-infringement opinion from attorneys, and conduct due diligence and based on the after thorough review of the technologies that are involved. Another scenario may be Indian company purchases a complete patent portfolio. I mean, if you are going to be a participant in a particular area of technology, often a way to jumpstart your position is to just acquire a whole portfolio. In such cases, these are the issues that come up. Does it include all relevant patents? What about third-party patents, not the ones which directly owned by companies that you're negotiating with? What about existing licenses, cross licenses, etc.? Again, due diligence should reveal most of these issues that can come up, and you have to take effective steps in overcoming that. Another possibility is Indian company merges with a division of a U.S. company. So again, I have listed out the issues and possible ways of overcoming these issues. And the risks of patent infringement liability in the U.S., again, you have to evaluate the patents and do due diligence on existing patents in that area of technology. I covered this in an earlier slide in a little bit detail, so I'll just skip through this. Again, there are some offensive strategies that you can involve. Basically, get your own patents for the technologies. And look at multiple countries and compare and what's the best source of protection of your ideas in multiple countries. So in the interest of time, I'll wind up at this point. Basically, the slides that I've put after this mostly deal with preparing a good patent application. What are the points that need to be looked into or taken into consideration? I'll be, all of us are available for the next couple of days, so feel free to approach us and discuss any specific issues that you may have in the time that we are available here. Okay? Thanks a lot. I really appreciate it.
Iyer, for your comprehensive presentation. You've given us an overview of the electronics and software industries. You've talked about the importance of developing an intellectual property strategy, including planning a global strategy, and you've made the points that you should keep a perspective on the future, you carefully select venues for investment, and carefully manage your portfolio. You've also talked about basic offensive and defensive strategies for an Indian company, as well as licensing of technologies, acquiring an IP docket, and mergers and acquisitions. So we've got a very broad overview of many important topics. I'd like to keep this interactive, even though we're limited on time, so I'll take 2 questions now. If we have time at the end, we might have some time for some additional questions. But if anyone has a question, please feel free to ask it now.
Yeah, I have a question.
Yes.
People did say that commercialization is a normal process. I think in India, that is a big burden, that there are a lot of good patents around, and we don't have much trolls here, as you said, patent troll, to help people commercialize. Got good patents. There are many companies that have hundreds of patents, and they're struggling. I mean, they don't have a strategy, and they don't know what to do with these patents. Some of them are very good. So what is it you can offer? But from your talk, it looks like in US and other countries, commercialization is rather easier than in India, but here it's a bear bug. There are no people who are willing to invest. How would you answer this question, sir?
Yeah, it's a good question. You are correct. The commercialization avenues are not as extensive here as in the US. More than commercialization, the first step, valuation of the patent, the economic valuation of the patents it's quite, even in the US, it's pretty difficult. A lot of the valuation strategies involve historical data. Now, when you don't have historical data, valuation techniques, even if you have, would not be of that much of a use. But at least it's a good starting point. Okay. Now, regarding commercialization, companies specialize in commercialization. ITAG is our partner in this. The organizers of this. It's a company that does commercialization for clients. So companies of that nature are coming up, but it's a challenge. I can understand. And large corporations are taking steps, like Indian Oil has floated a global tender for activities for commercializing their patent portfolio, developing and commercializing their technologies. And the interesting thing is, for a company like that, using your own research within your own company sometimes doesn't happen. So the research wing actually does the research and even gets a patent, but your actual manufacturing and fabrication units don't even know of, so the technology transfer even within the company is becoming an issue. Now, one way is maybe make R&D a separate profit center. So even if you're using within the company, the revenues for R&D are clear on paper. So all these avenues have to be explored. And soon, I mean, it's just a matter of time that pure technology companies like Intellecom Ventures, who are in the business of just getting technology and buying patents and enforcing them, or patent trolls, will start appearing. And I think it's a good sign.
In the interest of time, we have just room for one brief question and a brief reply. I think we had one more hand back here.
patent, I mean, how do you go about, if you're an innovator or inventor, how do you go about, evaluating your own patent, and, how do you kind of make sure that you get the right price for your, right money for what you've invented?
There are several models, about 6 to 8 models that are used. Some are based on cost, some are based on revenue. And back in January, we had a seminar of the similar nature where we covered valuation of patents in a significant. So I would, I would recommend you to go through those 6 or 8 techniques. And Dr. Agarwal, you may be having the presentation for that. Maybe that will be a good start. But again, that's better than nothing. Even if you have no data and it may be completely inaccurate or overbroad, but at least it's better than not valuating at all. So, a lot of the techniques arise from a case called Georgia Pacific back in 1970. This was a case that listed about 15 different aspects that you look at, and several mathematical models have come up. So, that will be a good start.
Okay.
All right. Thank you.
Thank you, Mr. Iyer.